Court is expected to rule on a new law banning high-capacity magazines.
The Supreme Court has rejected challenges to assault weapon bans in Connecticut and New York.
State bans on assault weapons, and the Supreme Court is at this point staying out of the fight.
In 2024, a Cowlitz County judge overturned the law, but the Washington State Supreme Court upheld it.
It includes the sale, import, manufacturing, and distribution of these magazines that hold more than 10 rounds.
A major win for gun safety advocates. The Supreme Court will not hear a challenge to Maryland's assault weapons ban.
Large capacity magazines are not necessary for self-defense and are routinely used in mass shootings.
All right, folks, I need to be straight with you. The Supreme Court just conferenced Duncan v. Bonta, Gators v. Ferguson, Viramontes v. Toth, and NAGR v. Lamont. Those are the four biggest Second Amendment cases sitting before the highest court in the country right now. And every single one of them got relisted. Again, no grant, no denial, just punted down the road one more time. And I'm going to be honest with you, that is not a good sign. I'm going to break down exactly what this means, what happens next, and specifically what you need to be preparing for if you live in California. The consequences there are unlike anything we've seen in the other states. Here's why this matters to you personally. If you own a magazine that holds more than 10 rounds, and for most of you with a standard Glock 17, a standard AR being a 15, basically any modern firearm, you own what California, Washington, Illinois, and Connecticut have decided to call a large capacity magazine. These four cases collectively challenge magazine bans and, in some instances, semi-automatic firearms bans across multiple states. If the Supreme Court denies certiorari, meaning they refuse to hear these cases, the lower court rulings stand. The bans stay. And in California specifically, we are not talking about a ban on future sales. We are talking about a ban on possession. That means magazines you already own, that you purchased legally, that have been sitting in your safe for years.
Justices will need to decide if this ban on magazines that hold more than 10 rounds violates the right to bear arms.
Washington gun store filed a petition with the U.S. Supreme Court in hopes to overturn Washington's high-capacity magazine ban.
State Supreme Court is expected to rule on a new law banning high-capacity magazines in Washington state. That is
also calling for another gun safety measure, a ban on high-capacity magazines.
California expects you to destroy them, surrender them, or get them out of the state. And the clock on that starts ticking the moment the court issues a denial. So no, this is not some abstract legal debate. This is about your property, your rights, and a ticking clock that could go off before the end of June. Let me walk you through what's actually happening procedurally, because the details here are critical. The Supreme Court holds private conferences where the justices decide which cases to take. Under the court's own rules, it takes 4 justices voting yes to grant certiorari. That's the rule of 4. If 4 justices want to hear a case, it gets scheduled for oral argument. If not, it gets denied, and the lower court ruling becomes final.
With the petition filed, we could see this move up to the Supreme Court if the justices find it to be nationally significant.
Much of the debate centered on if a magazine can be considered an arm or not.
Large capacity magazines are not necessary for self-defense and are routinely used in mass shootings.
Now, Duncan v. Bonta, that's the California magazine ban case that's been litigated for roughly a decade, originally filed in front of Judge Roger Benitez at the Southern District of California, has now been conferenced approximately 14 times. 14. That is an extraordinary number of relists, and here's why that matters. Last year, we watched a case called Snope v. United States go through essentially the same pattern. It got relisted over and over and over again. Conference after conference, only to be denied at the very end of the term in June. The parallels between Snope and what we're seeing with Duncan right now are impossible to ignore.
In typical self-defense scenarios where someone discharges a firearm, only 1 or 2 shots are fired.
In 2024, a Cowlitz County judge overturned the law, but the Washington State Supreme Court upheld it.
It includes the sale, import, manufacturing, and distribution of these magazines that hold more than 10 rounds.
Gators v. Ferguson challenges Washington State's magazine ban. Viramontes v. Toth is an assault weapons case out of Cook County, Illinois. NAGR v. Lamont, that's the National Association for Gun Rights, challenging Connecticut's bans on both semi-automatic firearms and standard capacity magazines. All 4 were conferenced last Friday, May 1st. All 4 were relisted with no action. And I should point out that going forward, the remaining conferences are shifting to Thursdays instead of Fridays. We still won't get the orders list until the following Monday, though. The next conference is May 14th. After that, there are only a handful of conference dates left before the court's final conference day on June 25th. right before summer recess.
The best way to honor victims isn't through symbolic prohibition of a particular category of arms, but by preventing the next attack.
Now, this proposed ordinance bans assault weapons, high-capacity magazines, and ghost guns.
I think Minnesotans are clear with us. They are in favor of a ban.
So let's talk about what denial actually looks like in practical terms, because it's very different depending on which case we're talking about. In Gators, Viramontes, and NAGR, the bans in those states are already in effect. There's no stay in place. If cert is denied, the status quo just continues. The laws remain enforced. It's bad, but the day-to-day reality for gun owners in those states doesn't change overnight.
The Supreme Court has rejected challenges to assault weapon bans in Connecticut and New York.
Alan Terrell, the state Supreme Court upholds the Protect Illinois Communities Act banning assault weapons.
Breaking news from the Supreme Court this morning related to the weapons used in the San Bernardino shooting rampage.
A major win for gun safety advocates. The Supreme Court will not hear a challenge to Maryland's assault weapons ban.
Bans dozens of specific types of rifles and handguns, 50 caliber guns, attachments, rapid firing.
Duncan is a completely different situation. Under Federal Rule of Appellate Procedure 41, when the Supreme Court denies cert on a case where the mandate has been stayed, meaning the lower court's order has been on pause while everyone waited for the Supreme Court to act, the stay dissolves. The Ninth Circuit Court of Appeals is then required to issue its mandate promptly after receiving that denial order. Once that mandate issues, California Penal Code Section 32310 kicks in with full force. And Section 32310 doesn't just ban the sale or transfer of magazines over 10 rounds. It bans possession, period. If you have them, California says you must permanently modify them to hold 10 rounds or fewer, take them out of state, surrender them to law enforcement for destruction, or turn them over to a licensed firearms dealer. There is no grandfathering. There is no grace period written into the statute itself, though the Ninth Circuit could theoretically build in a short compliance window under extraordinary circumstances. But that is entirely up to the Ninth Circuit, and given that court's track record on Second Amendment cases, I would not count on generosity. Now let me give you the broader picture. The Supreme Court decided New York State Rifle and Pistol Association v. Bruin back in June of 2022. That was the landmark case that established the text, history, and tradition test for evaluating firearms regulations under the Second Amendment.
The High Court found that the ban does not violate constitutional rights. Governor J.B. Pritzker signed the ban earlier this month.
Really about 5 major decisions left that we're waiting on, and they touch on extremely controversial issues.
There's been a lot of talk about restricting ownership of assault rifles, what are commonly called assault weapons.
They would not hear a challenge to the assault weapons ban in Connecticut and one in place in New York.
Under Bruin, the government has to show that a modern gun law is consistent with the nation's historical tradition of firearms regulation. Magazine bans have an extraordinarily weak historical argument. There is no founding-era analog to telling citizens they cannot possess a standard capacity feeding device for their firearm. Judge Benitez made that point explicitly in his district court opinion in Duncan. The historical record simply does not support it. And yet here we are watching the Supreme Court seemingly run out the clock on the very cases that would let them apply their own standard from Bruin to these laws. That is genuinely baffling. It's frustrating, and I think a lot of you feel the same way.
New law set off a firestorm of critics from gun rights advocates. In fact, it was quickly challenged.
The Supreme Court refused to take up a legal challenge to a city ordinance passed in 2013, strict assault weapons ban.
And Maryland quickly followed suit. 9 states moved to ban assault weapons and magazines.
State bans on assault weapons, and the Supreme Court is at this point staying out of the fight.
Now, we can be sure that whether we're here on Thursday, that the odds are getting higher that we're going to get one of those big cases.
I also want to put this in a broader context. There is a circuit split brewing on these issues. Different federal appellate courts are reaching different conclusions about whether magazine bans and assault weapons bans survive Bruin's historical test. That is traditionally exactly the kind of conflict the Supreme Court steps in to resolve. The fact that they appear reluctant to do so here tells you something about the internal dynamics of the court that frankly should concern every gun owner in America, regardless of what state you live in. If the court lets California's possession ban stand without review, that sends a signal to every other state legislature considering similar laws. New York, New Jersey, Hawaii, Massachusetts, they're all watching.
Declining to take this case and leaving the lower court ruling intact, it relegates the Second Amendment to second-class status.
Law enforcement members even signed a statement saying they would not enforce the law. The case eventually made its way to the Illinois Supreme Court.
Well, those state laws, of course, this means there'll be no challenge, no constitutional question about those state laws.
This could warrant a closer look in the next term or two. So it's not the final word, but at least for now in Maryland.
So let me give you my honest assessment. Am I certain these cases will be denied? No, nobody outside those conference walls knows for sure, and I genuinely hope I'm wrong. But the pattern we're seeing, 14-plus relists for Duncan, the snow precedent from last year, and only 7 conferences remaining before summer recess, all of that points in a direction I don't like. I'd put the odds of a grant at this point somewhere around 15 to 20%, maybe less. And that is painful to say, because when Duncan was first petitioned to the court, the case for granting it was overwhelming. The historical analysis under Bruin, the circuit split, the severity of the law, it checked every box, but the Supreme Court operates on its own timeline and its own internal politics. Right now, those politics do not appear to be in our favor on this particular set of cases.
You voted for the A50 amendment. You voted to keep firearms more easily accessible to convicted violent felonies. You voted to continue the sale of weapons of war, assault weapons, in Minnesota.
The bill includes $20 million for school safety and millions more for mental health support.
Restrictions on public carrying and safe storage, which includes stricter requirements for reporting lost or stolen firearms.
Here's your status check, and this is the part you need to remember. As of today, the stay in Duncan is still active. Your magazines are still legal to possess in California right now, but that could change with a single Monday morning orders list between now and the end of June. The next conference is May 14th, with the orders list dropping the following Monday. If you're in California and you own standard capacity magazines, you need to be paying attention to every single one of these conference dates. And for those of you in Washington, Illinois, and Connecticut, a denial doesn't change your current situation. But it does slam the door shut on your best path to relief at the federal level for the foreseeable future. We will be covering every single one of these conferences as the orders come down. That's it for today, folks. See you in the next video.